Well, good evening. Good evening. I want to test this microphone and make sure that we have a connection because every single time seems like we get ready to record, it seems like I seem to forget to hit the button of some sort, and we're not going to have that issue tonight. So those of you that are joining us tonight, I do want to thank you for your support. Please like, share, comment. Don't forget to subscribe to the YouTube channel. You can visit us online at www.fcnwatchdogmedia.org. If you'd like to reach out to us for support or assistance or advocacy, you can do so by reaching us by email at support@fcnwatchdogmedia.org. I'm Minister Marquis L. Kimble, the Executive Director of FCN Watchdog Media Global. Tonight, we're going to go over the reply that I filed in Lucas County Court of Common Pleas today in response to whatever the hell the scam was that Shinaver filed in the court. My reply covers what he talked about, so we're not going to give him any credit. We're not going to talk about anything that he put in his motion. We're just going to address it in what I put in my reply, so you guys can obviously follow along. And again, this is for educational purposes only. I am not an attorney. Neither is FCN Watchdog Media. We are not legal attorneys. We cannot give you any type of legal advice. So please do not reach out to me because you see what I'm able to do in court as a pro se litigant, and you think that I can assist you, because I cannot. That is against the law legally. I'm not an attorney. So the best that you're going to get from me is to contact an attorney. What I can do is show you how to properly form your documents, show you what courts to file in and the way they can be accepted by the clerk. That's the only thing I can do, and that's the only extension that I can offer anybody that reaches out to me. So keep that in mind, because I get a ton of emails daily with people requesting that I do this or I do that, and I'm going to tell you all the same thing. I'm not an attorney, and I cannot offer you any type of legal advice or assistance. All right, so in the Court of Common Pleas, Lucas County, Ohio, Marquis L. Kimble, plaintiff versus Joseph W. Shinaver Jr., defendant. Judge Lindsay D. Navarre. Plaintiff's response in opposition to defendant's motion for sanctions and in further support of motion to lift stay of proceedings. So you guys understand what this whole dispute is about. This guy is literally doing everything he can to not allow the stay to be lifted in Lucas County. What are we talking about? He was able to enact a stay on the civil rights case against him and his law firm, due to making the court believe that there was some type of an appeal process going on, despite the fact of him losing multiple times in the county that he filed this whole entire scam. So the reality of it is he's asking the court to keep a stay on a civil rights case against him and indefinitely. But then as of today, it looks like he's now trying to ask the court to punish me with sanctions and label me as a vexatious litigator. Same thing that Swanton Police Department pulled. It's the same thing. You won't address the merits of what you did wrong. You won't address what you did wrong to anybody because you don't want that to come out. Instead of you addressing where you violated the rights and where you went wrong, you're going to try to paint me as a criminal. You're going to try to paint me to the court that I should be, admonished or sanctioned or reprimanded because you feel so. When your actions show that you're the guy that should be labeled as such. All the things you've done. Who files so much stuff in court and gets told no, but continues to file these things, and then he's not labeled as frivolous? But because I am attempting to hold you accountable in the court of law, which is a legal right given to me as a United States citizen, I have a right to try you in the court. Now it's up to the court. Why don't you want to let the jury hear this? Let's talk about that, because it's always the people that are the defendants that don't want to let the jury hear it. See, I don't have a problem with allowing the jury to hear it. You have a problem. Why? Because anybody with a half of a brain that sits on that jury panel is going to see the scam that you have been doing this entire time. Why? Because we've We've been documenting every step of the way. You should know by now that whatever you try to file, whatever kind of scam you think you're going to run in any type of court, not only am I notified, but when I'm notified, you don't know who I have working for me, guys. So I would suggest that you get better at what you think. You think that this is just a one-man show. No, buddy, I wish you would understand that I have eyes everywhere. So when you file something, someone is letting me know. And as soon as I see that you filed, then I'm attacking whatever it is you filed. I'm looking at it. I'm reading it line by line, because you're not talking to a pro se litigant that does not understand his filings. I mean, that's not you're talking to a person that spends hours, days, weeks, and months studying out where you guys violated the law, and we're going to hold you accountable. You can try to run all you want, because after talking to the Court of Appeals today, even this crap that you're trying to pull in Lucas County doesn't matter, because according to the Court of Appeals, it's only going to be a 60-day process, guy. So even if somehow the Judge Navarre allows this scam to continue, your time is running out, buddy. And you're going to have to face the music. And this time, when you face the music, you're going to not only deal with me, but you're also going to deal with Mr. Amato, the president of FCN Watchdog Media, who you also filed a false fake protection order against as well. Not because you were in any fear of your life, but because you disagreed with our social media posts and our approach on how we exposed your scam. So at the end of the day, when we go to court for trial, I'm going to file a motion so I don't have to say anything else, because I don't want to talk to you anymore. You're an idiot. You're not even worth my time. I've spoke all I need to speak. I've said all I need to say. I've filed all the motions I need to file. And now, guy, I'm done. You're an idiot. You're like scum on the bottom of my shoe, and I don't care to talk to you at all. So I'm going to file a motion so I don't have to speak at all at the trial. And we're going to let Mr. Amato hand you your ass to you on that stand, because you did wrong and you're continuing this thing. See, at the end of the day, we could have been men about this, but you want to continue to act like a child and continue to go forth with baseless motions. And now you're trying to punish me through the courts for doing what the judge asked me to do. You scam. So anyway, plaintiff Minister Marquis L, Kimble, pro se, respectively submits this response in opposition to defendant's motion for sanctions, and consistent with this court's April 21st, 2026 order, further supports his renewed request that the stay be lifted. Again, we're fighting about this scamified stay that Shinaver got placed on this case because he's trying to run from the scam. You don't get to create a scam and run from it. It's almost like you want to you want to come up and punch me in the face and then control how I react to it. It doesn't work like that, guy. You did the illegal things and foul things and violated my rights, and I used the courts to file against you. That is 1000% legal, and you don't get to cry me, oh, I don't like it. Oh, you don't get to do that, guy. You violate. If you would not have committed these violations, we wouldn't even be here today. See, back in October, when the police showed up and took my weapon from me and you had me branded as a dangerous stalker, you didn't give a damn what that did to me. You didn't care how it affected my job opportunities, how it affected my professional name, image, and character. You didn't care about any of that. You lied to the court and then went in there and on the record said that you were never afraid of me. You said it twice on the record. Do we have to pull the audio? So if you were never afraid of me, then why in the hell would you even file a protection order against me? You were trying to control my freedom of speech, and you don't get to do that, guy. You don't get to do that, especially when we are a nonprofit civil rights organization and media organization. Now, you're mad. It'd be one thing if I was out here slandering your name with lies. But when I tell the public what you and your partner, Zach De Silvas, did to me and my business and my family, I'm now the one that should be labeled as a vexatious litigator and be punished through the courts. Are you kidding me? Where's your punishment for lying to the Judge Navarre about your appellate process when you lied and said, oh, I've got an appeal going on, but you never paid for it? See, now, if I did that, it would be lying to the court. But because you're an attorney, somehow this stay got to stay in place, which is a scam all in itself, because you lied. You told the court something that was not true, and somehow you were able to enact this stay. Well, the reality of it is your scam is falling apart, and it is on the record what you've done. So you can say whatever you want to say about me personally. It doesn't get rid of the facts. It doesn't erase the facts that you violated my rights. And you're going to pay for it, guy. So it was consistent with this court's April 21st, 26 order, further supports his renewed request that the stay be lifted or at minimum not extended, because the related Ottawa County appeal is fully briefed, procedurally stable, and now reflected in a clear judicial record. Plaintiff further submits that the present sanctions motion appears retaliatory. So, Guy, I don't know why you didn't think that for some reason you were going to file this scam in Lucas County and I wasn't going to address the retaliation that it looks and appears that you're doing. How is it all of a sudden you want to file sanctions? The judge didn't ask for that. She asked for orders in Ottawa County so she can make a decision on the stay. And you come with all of these motions. I hope she admonishes you again on the record so you look more like an idiot. She was very clear in the order what she wanted. And because you don't like how the order looks and makes you look when you're the idiot that did it all, you come back with all these extra motions and things that she did not ask for a day before the deadline. I hope she corrects you, Guy. I stayed within what she required, what she clearly said on the docket and on the order. You did what you wanted to do, and you don't get to do that. So, procedurally stable and now reflected in a clear judicial record. Plaintiff further submits that the present sanctions motions appears retaliatory when viewed alongside the parallel federal civil rights proceedings pending before the Honorable Jeffrey Helmick in Kimble versus Swanton Police Department. Again, all of these bastards are related. And he starting this stuff in the state of Ohio, this is a separate action because it's something that he did additionally on top of why they're in federal court. Now, we've already talked about why they're in federal court. Mr. Zach De Silva's told me somehow 2 weeks or approximately 2 weeks before our scheduled trial in federal court, Fulton County Court against State Farm, he told us somehow that either we settled the complaint or we faced criminal charges, and he would not be the attorney that would be representing us after we waited in a year to see a judge. And then not to mention the Fulton County judge had to recuse himself from the case because of conflict of interest. So somehow, whatever you want to say, however you want to slice the pie, the plaintiff in the case, Marquis Kimble, never got his day in court. Matter of fact, we were called to the courthouse, and me and a witness of mine, matter of fact, that witness happened to be Mr. Amato. We came to the court that day, and we were told to sit in the hallway. And you know who went in the courtroom? Zach De Silva's State Farm's attorney, Jeff Lambert, the agent that shared our personal information under oath. See, we're not just coming up with bare allegations. All of these people and the judge, Judge Bates, they went into the courtroom and I don't even know what was discussed in there. All I know is 2 weeks before we were supposed to go to trial, I was told I better drop the case and refile. And I had a year to refile, and the attorney, Zach De Silva, who was our attorney, made it clear he would not be representing us. You want to tell me there wasn't any scams involved there when there's clear evidence of bad faith insurance practices by State Farm all through this claim? Then not to mention the whole entire time while we're going through a baseless investigation held by State Farm, I'm told by Zach De Silva's multiple times, and I've got witnesses that are going to be at the trial on the stand if they've already agreed. Witnesses where Zach kept telling me over that entire year, don't go after the police because you're going to ruin your bad faith claim with State Farm. That's what his legal advice was over the entire year. So regardless that the police violated my rights, violated my sister's rights, neglected our business, did all these things, the mayor himself promised additional investigations, never did any of this, dropped the investigation 6 days after the break-in. All these things transpired. but yet I'm supposed to believe that there was no type of scam involved? No, discovery is going to bring out the scam. And as I was telling this to the public and exposing this, Mr. Shinaver decided to surveil and record and monitor my social media platforms while I'm litigating Zach Da Silva's in the Supreme Court. Now, you want to tell me how ethical that is? When I told the public that's what he was doing, he then reported all of our pages and groups as harassment and filed a protection order in Ottawa County Court of Common Pleas and got it issued without me even being there. Now, you want to tell me how that is not a violation to the 10th power, like my mother used to say? So the police can just show up and take my property from me and tell me because some guy said something, and then when he gets to court, he says, oh, I didn't really mean that. I'm not scared of you. Matter of fact, if we can just squash this whole thing right now, if you just agree to tone it down, I'll squash this whole thing, is what he said to me after he started all of this. He said this on the record. So why are we here today? Because Shinaver wanted to be here today. And obviously by his responses, he wants to keep this thing up. And I have no problem with responding to any scam that he thinks he's going to put across that docket. So again, this is a retaliation move here, where plaintiff has sought leave to amend and to add Shinaver Law Office and Zachary Da Silva's. So again, now you want to come with this, sanction him and this to him and this to him. But the reality of it is there's a pending complaint sitting before a federal judge where you're named as a defendant. What do you mean? This is retaliation to the 10th power, you scam. What makes you think this is not? And you're going to really try to ask the court to sanction me when I gave them what they asked for? Judge Navarre was clear in her order. I gave her exactly what she asked for. And because of that, because you look like an idiot on that record, you're going to ask the court to punish me. Get out of here, guy. You are supposed to be an attorney. You should be ashamed of yourself. You are a disgrace, guy. I'll say it again. No intentional misrepresentations. 6 district orders were accurately described. Defendant's motion rests on the accusation that plaintiff intentionally concealed 6 district orders and fabricated the procedural posture of the appeal. That's a complete bold-faced scamified lie. How could I do that when I provided everything that I filed and he filed to the Court of Appeals to Lucas County? Go look at the exhibits. So how could I be hiding anything, guy? It looks like you're the person that's hiding stuff. Why didn't you tell Judge Navarre about your denial for the Rule Civil B argument? Why didn't you tell her about that? Why didn't you tell her that all of your objections were denied by Judge Bruce Winters in Ottawa County? Why didn't you tell her that? Huh? You didn't tell her any of these things. But because I told it to her so she could have a clear picture like she said, you're now trying to come back and say, punish him. Get out of here, you son of a bitch. Plaintiff's May 4th, 26 notice referenced and attached the April 30th, 26 6th district order denying appellant's request for oral argument. This idiot asked the Court of Appeals for an oral argument after losing all these times. So let's get this straight. He files a fake protection order. He didn't expect me to show up for trial, but I did. What should have been an hour-long session turned into a 2-day trial. The first day, this guy beat me up like you wouldn't believe. And I had to sit there and take it. He showed all his evidence. He had the floor. The judge gave him the full floor to present his case of why there should be a 5-year protection order put on me. The second day, it was my turn. I questioned him. I didn't even show any evidence. I just went off of the truth, what truly went down, what truly happened. And then after that 2-day trial, it took them over 90 days to make a decision. But after the decision was made, they decided that this guy was a scam and this protection order was not valid. There's no fear for your life, guy. You're done. He didn't like the decision by the magistrate judge. So he goes back and deals with Judge Bruce Winters, who is the Fulton County or the Ottawa County Court of Common Pleas judge. And he tries to present objections and bring additional evidence in front of Judge Bruce Winters. Bruce Winters objected or basically denied every one of his objections and then recused himself from the case. So he signed off of the cases. He said, not only am I not going to hear any of your objections or your evidence, if you got evidence against this guy, you need to take it to Lucas County. Pretty much what he told Shinaver. And then he signed off of the case. Because he signed off the case, the Supreme Court had to appoint a new judge. Visiting Judge James Bates came in and took the reins. This idiot Shinaver decided yet again, I'm going to try again to re-argue this because he can't take the fact that he lost. So he decides to try a backdoor argument with a civil rule B argument, meaning that there was something, he claimed fraud. He basically claimed that I was trying to extort him and this is evidence and they need to reopen the case. Judge Bates heard all of that, looked at the argument and said, no, it's over. It's not going to happen. If you have evidence against Kimble, again, needs to be handled in Lucas County. This guy decided to go to the Court of Appeals, ask the Court of Appeals, can I have an oral argument? Meaning that I need to be able to present this live in front of you judges. And they told him no. And he still thinks he has a narrow way to an appeal when anybody that knows anything about the appeals, the only way he would be able to get approved for appeal at this time is he's going to have to prove and show that the trial court made an error. Well, that's very hard to do when you've already had a magistrate judge and two judges back the trial court's decision. So stop it, guy. You should know better. You are an attorney, so I thought. You went to the College of Scam. Admit it, guy. So, defendant's motion rests on the accusation that plaintiff intentionally concealed the 6th district orders and fabricated the procedural posture of the appeal. Those accusations are unfounded and miscategorize both the plaintiff's May 4th, 26 notice and the 6th district record. So again, my notice is in accordance with the 6th district record. So I want you to please explain to me what I did wrong when the judge specifically asked for anything concerning judicial opinions, entries, judgments concerning the Ottawa County trial. Plaintiff's May 4th, 26 notice referenced and attached the April 30th, 26 6th district order denying appellant's request for oral argument because that order squarely confirmed what plaintiff has consistently represented to this court, that the 6th district will decide the Ottawa County appeal on the briefs without oral presentation. That was just me making sure that Judge Navarro was aware of that. Plaintiff highlighted plaintiff highlighted that order for the narrow purpose of showing that no further oral hearing would inject additional factual development or unpredictability into the Ottawa County appeal. Again, that clearly states why it was put on the record that this guy's oral argument request was denied. He just doesn't like that because it makes him look like an ass to the judge. Because now you were denied the protection order, you were denied the objections, you were denied the Rule Civil B argument, and then now here you come asking for an oral argument, and they denied you there too. He doesn't want that, but yet he wants to try to say like I'm trying to mislead the judge. No, buddy. You can go through all my exhibits. I never once tried to mislead the court. You are the guy that lied about the appeal. You're the one that said, hey, judge, freeze the case because I have an open appeal right now. You didn't even send the damn check, guy. You didn't even pay the money. So if I used an excuse in the court and never paid the fees and I can get away and get stuff done, no, you did that because you're an attorney. Anybody else wouldn't have been severely addressed by the judge if they went and filed something or said to the court that they filed something that they truly didn't file. It's a first grader knows that if it's not paid for, it doesn't matter what you did on by email. Who cares? We're in court. This is not about feelings, guy. It's about what is facts. And if you didn't pay for it, it doesn't exist. You told the court on the 2nd of March that you were in the middle of an appellate process. The appeal wasn't docketed by Ottawa County until March 9th. So why did you lie? You lied to Lucas County. I don't care how you slice the pie. So, defendant claims plaintiff hid an April 27, 26 order and an April 30th, 26 sua sponte order concerning briefing. But the April 30th sua sponte order does not contradict plaintiff's description of the appeal as being decided on the written submissions. It confirms that the parties will be notified when the matter is submitted to the court for determination on their briefs. Plaintiff's representation that the appeal would be decided on the briefs and that the docket was no longer in an exceptional or fluid posture, as the way Shinaver tried to make it seem, so he could get this stay enacted, in the sense of awaiting new issues or hearings, accurately reflects those orders. Again, there's nothing new here. There's nothing else to be heard here. This guy is a scam, and he's trying to keep up the scam because he doesn't want to be known as the guy that lost this many times by a pro se litigant. He's an idiot. He has a law degree, and he's fumbling. He's fumbling out. He looks like a complete clown idiot. Don't hire the Shinaver Law Firm. I mean it. He's a scam. Any omission of the April 27, 26 reinstatement order and the April 30th, 26 sua sponte order from the May 4th, 26 notice was not deliberate or deceptive. Plaintiff expressly acknowledges those orders, their dates, and their content, and does so on the record in this filing. Plaintiff's prior filings in Ottawa County, including his April 30th, 26 appellee's brief in opposition. So he tried to ask for an appeal, and of course, I argued back and said, no, he doesn't deserve an appeal. Why? Appeal what? How many times does a court got to tell you no before you get the picture, you scam? So of course, I came back with a brief in opposition to his request to appeal. And his April 21st, 26 response in opposition to appellant's request for oral argument. So when he tried to go get the oral argument, I went to the Court of Appeals and said, no, hell no. Why does he get to argue it again orally when, again, it was already decided about? The Court of Appeals is looking for, if there's a mistake, if there's something that was done unlawfully, then that overrules. But you don't get to go to the Court of Appeal because you don't like how something turned out. This is the way it looks, clearly. You didn't like the outcome, and now you're trying to get an appeal and then make the judge in Lucas County believe it's a real appeal when you know good and hell well it's not. Likewise, openly described the reinstatement, the briefing sequence, and the denial of Civil Rule 60B relief after remand. Plaintiff's May 4th notice focused on the April 30th order, denying oral argument, because that was the most recent order defining how the appeal would be resolved on the written briefs and record. And that procedural reality is precisely what this court asked the parties to clarify when it granted leave to file supplemental exhibits to give this court a fully informed picture of the status of the Ottawa County proceedings. Again, it's what she asked for. Under Civil Rule 11, the question is whether plaintiff knowingly advanced a false factual contention or used the May 4th notice for harassment or delay. Defendant's own exhibits show that the 6th District Appeal is in fact to be decided on the briefs, that the Ottawa County Trial Court has already denied both the CPO and later Civil Rule 60B relief, and that plaintiff has consistently stated those facts. There is no willful misrepresentation to sanction. Plaintiff complied with this court's April 21st, 26 order. This court's April 21st, 26 order granted limited leave until Wednesday, tomorrow, May 6, 26, for the limited purpose of allowing the parties to supplement their respective motion and responses regarding the what? Stay of proceedings only, with exhibits such as judgment entries, court-issued opinions, or orders, to give this court a fully informed picture of the status of the Ottawa County proceedings. That was the judge's orders. Everything plaintiffs submitted falls squarely within those parameters. On April 22nd, 26, plaintiff filed plaintiff's supplemental exhibits 1A, 1B, and 1C in support of motion to lift stay of proceedings. Those exhibits are as follows. Exhibit 1A, Ottawa County Common Pleas Court Judgment Entry dated February 2026. Journalized February 23rd, 26 in case number 25 CVH 702. Adopting the magistrate's decision after full hearing and denying the civil stalking protection order, including terminating the ex parte CPO effective November 19th, 2025. So again, that's the original scam. It was denied. He got it enacted in October. And even though they didn't make a decision until February, again, I told you guys, this guy got this thing done in October for some reason. And from October to February, I was told, or until I got the notice that this was denied, I could not carry my weapon. And I had to walk on eggshells because this guy was literally he even tried to get a contempt of court charge on me because I didn't stop talking. As if he can control what happens on our social media platforms. What the hell planet does that happen on? So this was just showing what happened. Exhibit 1B, Ottawa County Common Pleas Court Judgment Entry dated April 15th, 26. Denying appellant's Civil Rule 60B motion after the 6th District's limited remand and expressly noting that the later evidence, this is key here, he was trying to say he had more evidence. Appellant relied on may be relevant to the Lucas County case. So, once again, we have a judge here that's saying, whatever evidence you have, guy, you can present your evidence, but to do it in Ottawa County with a already decided case that you lost is not the proper avenue. So this judge pointed out, you need to be in Lucas County. He doesn't want to be in Lucas County. He wants it to be froze. Exhibit 1C, relevant petition pages from the Ottawa County CPO filing showing the nature of the allegations and the broad relief requested, including attempts to restrict plaintiff's social media post reviews and content removal. The April 22nd submission expressly stated that it was in compliance with this court's April 21st, 26 order and was limited to supplementing the pending stay motion papers with court-issued materials regarding the Ottawa County proceedings. Again, that's what she asked for. The exhibits themselves are exactly the type of materials this court invited, and they show the CPO was denied after full hearing. The ex parte order was terminated. The Civil Rule 60B motion was denied after remand. The Ottawa County Trial Court itself recognized that later materials appellant relies on belong, if anywhere, in this Lucas County case. Plaintiffs later May 4, 26 noticed by adding the 6th District's order denying oral argument and describing that the appeal will be decided on the briefs, remain in that same narrow lane, providing this court with appellate orders that illuminate the present procedural status, not supplementing argument beyond what this court's authorized. The record therefore shows compliance, not defiance of this court's instructions. The Ottawa County appeal is fully briefed and procedurally stable. The judicial record in Ottawa County and the 6th District now reflects a completed merits process with no remaining fluid or open-ended issues that justify continuing or expanding the stay. Merits denial of the CPO and termination of ex parte order. The Ottawa County Common Pleas Court denied appellant's petition for the civil stalking protection order after a full evidentiary hearing on November 4th and 5th, 2025, finding that it could not conclude, even by a preponderance of the evidence. And he showed hundreds, I don't even know how many videos this idiot showed. He had all my pages pulled up on the screen and everything. But they said by a preponderance of the evidence that the plaintiff's conduct rose to the level of menacing by stalking, and that the appellant and his family were not in immediate and present danger. The same judgment entry terminated the ex parte protection order as of November 19, 2025. Denial of the Civil Rule 60B relief after remand. On March 27, 26, the 6th District remanded for the limited purpose of ruling on the appellant's Civil Rule 60B motion. So he threw that in at the last minute. A backdoor way to try to retry a case, you stupid idiot. On April 15, 26, visiting Judge James Bates denied that motion, expressly concluding that the later evidence and exhibits appellant relied upon may be relevant to the Lucas County case, but were not relevant to the magistrate's decision at that time. So again, guy, why are you running? Why are you running so fast? So why are you trying to keep this case out of Lucas County? Why, guy? Because you know what's going to happen. This entry closed the only outstanding post-judgment issue identified by the 6th District and confirms that Ottawa County is not the forum for resolving the broader civil rights and defamation issues that underpin this Lucas County action. Appeal fully briefed and set for decision on the briefs. Plaintiff's appellee's brief in opposition was filed and accepted in the 6th District, setting out the procedural history. The full hearing denial of the CPO, the termination of the ex parte order, and the post-remand denial of Civil Rule 60B relief. Plaintiff also filed a response in opposition to appellant's request for oral argument, explaining that the issues are fully presented in the written record and that the oral argument would not materially aid the 6th District. The 6th District subsequently denied appellant's request for oral argument and stated that the appeal will be decided on the briefs and record. A separate April 30th, 26 sua sponte order clarified only that plaintiff's brief had been filed on March 9th, 26, and that the parties would be notified when the matter is submitted for determination on their briefs. That clarification further underscores that the appeal is fully briefed and procedurally stable. Given this posture, any continued stay must rest not on speculation about unresolved Ottawa County proceedings, but on the legal effect of final judicial rulings already in the record. Those rulings are adverse to appellant. He lost at a full hearing, the ex parte order was terminated, and his Civil Rule 60B motion was denied. The appeal now presents narrow questions of trial court error, not an unfolding fact pattern that needs to be watched before this civil rights case can proceed. Parallel federal proceedings before Judge Helmick underscore the retaliatory character of defendant's sanctions request. In addition to Ottawa County proceedings and this Lucas County action, plaintiff is prosecuting federal civil rights claims in the Kimble versus Swanton Police Department, pending before the Honorable Jeffrey Helmick in the United States District Court for the Northern District of Ohio. That case arises from related patterns of police, municipal, and attorney misconduct that plaintiff alleges were aimed at suppressing his advocacy and media work. In that federal action, plaintiff has sought leave to amend his complaint to add, among others, defendant Joseph W. Shinaver Jr., Shinaver Law Office, LLC, and attorney Zachary De Silvas as parties based on their intertwined roles in the events and retaliatory tactics described in the operative and proposed pleadings. Plaintiff understands that Judge Helmick currently has plaintiff's motion for leave to amend under advisement. Against that backdrop, the timing and content of defendant's motion for sanctions in this court are not coincidental. Defendant seeks sanctions here at the same time plaintiff is asking a federal judge for permission to name defendant and his law firm as civil rights defendants. That sequence strongly suggests the sanctions request is not a neutral effort to police litigation conduct, but part of an escalating campaign of retaliation and counterattack designed to deter plaintiff from pressing his claims in state and federal forums. Viewed in the light of Kimble versus Swanton Police Department, defendants' effort to brand plaintiff as a vexatious litigator, obtain fee shifting, and keep this case stayed functions as a tactical move aimed at chilling plaintiff's exercise of his First Amendment right to petition and his rights under 42 U.S.C. 1983, rather than as a good faith invocation of Civil Rule 11 or RC 232351. Plaintiff respectfully submits that this court may take notice of the existence and posture of the federal action and consider, in assessing defendant's credibility and motive, that the sanctions motion here targets the same core advocacy activity that is the subject of the pending federal civil rights claims. Defendant's accusations and vexatious narrative are personal attacks, not a basis for sanctions. Defendant's sanctions memorandum reprises the same rhetoric already used in his December 22nd, 25 motion to have plaintiff declared a vexatious litigator in this court, which accused plaintiff of harassing conduct, retaliatory lawsuits, shakedown tactics, extortion-like behavior, and similar labels. Those assertions should be understood as advocacy and character attack, not as findings of this court or as a legal basis to punish plaintiff for complying with the April 21st, 26 order. Under RC 232352, a vexatious litigator is someone who habitually, persistently, and without reasonable grounds engages in vexatious conduct in civil actions, where vexatious conduct is narrowly defined to include acts that are obviously served merely to harass or maliciously injure another party, are not warranted under existing law, or are imposed solely for delay. The record before this court shows plaintiff has used the precise channels the law provides, including filing civil actions and forms with connections to the underlying conduct, filing disciplinary grievances through the Office of Disciplinary Counsel, filing complaints with agencies like the Ohio Civil Rights Commission, and seeking remedial relief when subject to a CPO petition that ultimately failed on the merits. Ottawa County has already adjudicated defendant's attempt to recast plaintiff's speech and advocacy as menacing by stalking and rejected that theory, finding no immediate and present danger and denying all requested CPO relief. Ottawa County, after remand, explicitly recognized that certain evidence defendant now highlights may be relevant to this Lucas County civil case, not to the CPO decision, reinforcing that plaintiff's use of this forum is substantively grounded, not frivolous. This court previously admonished defendant for his own premature motion practice in connection with the appeal, noting that his motion to stay was filed before the Ottawa County clerk actually accepted and docketed the notice of appeal, and expressly admonishing him for the premature filing of his motion to stay in this matter. When defendant's vexatious narrative is measured against the legal standards, it is his pattern of broad collateral attacks on plaintiff's character and ministerial work, combined with the efforts to leverage the Ottawa County CPO and appeal to freeze this civil case, that more closely resembles conduct aimed at delay and reputational harm than efficient resolution on the merits. Plaintiffs' targeted submissions limited to court-issued entries and ordered as directed by this court do not meet the statutory threshold for vexatious conduct or frivolous conduct under RC 232351. Defendant's own conduct undercuts his sanctions request. The record contains multiple examples of defendant's conduct that weigh strongly against granting sanctions and that this court may consider in assessing credibility and motive. Defendant previously obtained a stay based on a notice of appeal that, as this court found, was not actually processed and docketed in Ottawa County until March 9th, after the filing fee was received, prompting this court to admonish him for prematurely seeking a stay. Defendant has used this case to seek and order branding plaintiff as a vexatious litigator, requesting sweeping restrictions on plaintiff's access to the courts and on entities he directs, accompanied by extensive rhetoric about plaintiff's social media conduct, content, advocacy, and business activities. Defendant simultaneously portrays plaintiff as so dangerous that extraordinary restraints are needed, while himself sending direct email communications to plaintiff from a no-reply law office addressed in the midst of litigation. That asymmetrical posture undercuts any claim that plaintiffs' measured court-directed filings about the appeal status are the kind of bad faith harassing conduct that warrants sanctions. Against that backdrop, defendants attempt to convert a good faith limited supplemental filing guided by this court's April 21st, 26 order into grounds for fees, and punishment is itself an extension of the vexatious narrative already rejected in substance by Ottawa County's denial of the CPO and denial of the Civil Rule 60B relief. Requested relief. For all of the foregoing reasons, including the Ottawa County's merits rulings, the now stable status of the 6th District Appeal, and the context of the related federal civil rights proceedings before Judge Helmick, plaintiff respectfully requested this court deny defendants' motions for sanctions under Civil Rule 11 and RC 232351 in its entirety, find that plaintiff's May 4th, 26 notice did not contain intentional misrepresentations, that any omission of specific 6th District orders was not deliberate or deceptive, and that plaintiff has fully acknowledged and described the April 27th and April 30th, 26 orders on the record. Recognize that the plaintiff's supplemental filings, including Exhibits 1A, 1B, and 1C, and the 6th District appellate orders fall squarely within this court's April 21st, 26 directive to give this court a fully informed picture of the status of the Ottawa County proceedings. Conclude that the Ottawa County matter has reached a procedurally stable posture, CPO denied, ex parte order terminated, Civil Rule 60B relief denied, appeal fully briefed and to be decided on the briefs, such that a continued or expanded stay is no longer justified on the basis of unresolved Ottawa County proceedings. Further, conclude that in the light of the pending Kimble versus Swanton Police Department action and plaintiff's motion for leave to amend now before Judge Helmick, defendant's sanctions motion appears retaliatory in nature and should not be rewarded with fee awards or other punitive relief that would shield plaintiff's pursuit of his federal and state civil rights claims, and lift the stay of the proceedings in this case, or at minimum decline to extend it further, so that the merits of the plaintiff's civil claims may proceed to adjudication in the form that Ottawa County has already recognized as the proper venue for those issues. Shinaver, certificate of service, signed, sealed, delivered. You scam. We are not going to give up anything whatsoever when it comes to you, buddy. You're going to deal with what you did, and we're not going to give up. We're going to continue to hold you accountable until there's consequences for your actions. Peekaboo guy, we see you.